Buyer beware, sold as seen, trade sale, no returns, no refunds or exchanges, without warranty, or in some cases, no representation given as respect to quality. All of these phrases are completely and 100%. Welcome back, I'm the Black Belt Barrister helping you to understand law. So I was reminded of this phrase a good few times in the last week or two, both when I was out shopping for certain things, because I was told exactly this phrase a few times and I didn't make any comment about it. But this phrase, sold as seen, is thrown around quite a lot, but actually has no legal bearing whatsoever. All of these phrases are completely and 100% meaningless. This is quite prevalent and quite prominent among second-hand car sales, but also of furniture and various other things. Now, bearing in mind I am talking about buying from a trader as opposed to your friend down the public house. You buy something from a trader and you are a consumer, then the Consumer Rights Act applies. If you're a business, then that is where you'll go back to the old Sale of Goods Act, but I'm talking about consumers in this particular video. So when they tell you that it's sold as seen and buyer beware and no representations made as to quality and all of these kind of things, those do not override your statutory rights within the Consumer Rights Act. And those, irrespective of it being a second-hand product, including a vehicle, are as follows. There are more rights than these, of course, but the primary ones are that it must be of satisfactory quality, it must be fit for particular purpose, and that is a purpose even if you make that purpose known to the trader, even if it is not normally used for that purpose. If you make that purpose known, it must be fit for that particular purpose. And it must also be as described in any advertisement. In fact, there are lots of laws preventing and prohibiting misleading advertising. So no matter you are purchasing a vehicle or any other item, whether it be for £100, £1,000, or even £100,000, even if you're paying £100,000 for a second-hand vehicle from a trader, it still engages the Consumer Rights Act and all of the rights therein. The Consumer Rights Act provides you, as a separate part of the Act, as another right, you have the right to enforce your rights under the Consumer Rights Act. So if something is wrong with it, it's not as described, it's not fit for purpose, it's not of satisfactory quality, you have the right to enforce those terms as terms of the contract, irrespective of whether or not they write on the piece of paper, sold as seen, no warranty, and all of these kind of things. And therefore, if the product does not meet any of those terms, which are part of the contract, whether the trader likes it or not, you can enforce those terms. You have a right to enforce those terms as a matter of contract law, and therefore the trader will be in breach of contract if any of those things are breached. You therefore have several remedies, not least of which the standard good old breach of contract remedy, which is you take them to court for a breach of contract, but the terms are enforced as a statutory right, a statutory provision, a statutory implied term of the contract by the Consumer Rights Act. And in doing so, you have various remedies under the Consumer Rights Act as well. This comes in the form of timeframes. First of all, if it's a distance or off-premises sale, then you have a cooling off period with no reason given whatsoever. Although there might be something about the shipping where usually the trader can make you pay for return shipping, but otherwise you don't need to give any reason to return it whatsoever. You could, in most cases, even have opened the item first of all to examine it, unless of course it's something that shouldn't really be returned, such because for health reasons, or maybe it's a digital product and once opened obviously you've got access to the digital content. So there are some exceptions, but in most cases, even if you've opened it, it doesn't really matter. So sometimes the trader will say to you, it must be unopened in its original packaging. But for the most part, that's not true. You've got this 14-day cooling off period within which you don't have to give any reason whatsoever. You have the right to return it. This is actually derived from the Consumer Contracts Regulations of 2013. So just as a slight tangent based on all of that, what is a distance or an off-premises sale, you might ask? Well, if you get salespeople come out to your house, that's an off-premises sale because you are not on the trader's premises. If they are not there, then it's a distance sale because you're probably on the phone or you're doing it online. So either way, you are not on the trader's premises, you haven't had the opportunity to physically examine the goods, or you are not physically there within the shop, looking at the thing. Therefore, you've got this 14-day cooling off period within which you can cancel for no reason whatsoever. This differs, however, from being in the shop having examined the goods. You cannot then, as of right, just return it because you've changed your mind. Although most shops are quite good about that, and they do give you a return period within which you can just change your mind and bring it back. Although then they might insist that it's in its original packaging and being unused. But other than that, on the assumption that one of these statutory implied terms of conditions, such as satisfactory quality, fit for purpose, and as advertised, and so on, you have other rights to reject, and these come with their own timeframes. The first of which being within 30 days of purchase. You have a right to return for a full refund, and that does include even second-hand cars that might be £100,000 worth or even more from a trader. You still have this 30-day right to reject that vehicle for a full refund if it doesn't meet those minimum terms implied by the Consumer Rights Act. Very often they will offer to repair the vehicle. I'll come back to that in a moment, because there's a little gem of law that many lawyers don't even know, which is very useful to you when you are in some kind of dispute, particularly I find in the cases that I've instructed on with car dealers, traders, and second-hand vehicles. So watch out for that just in a few moments' time. The second period kicks in between 30 days and 6 months, because you don't have a right to a refund within that period of time, but you do have the right to a repair or a replacement. But they have one opportunity to repair before you then get the right of final rejection, i.e. they've tried to repair it once, they've failed, then you can say, forget it, I want my money back. It's worth noting, however, that if a fault develops or is noticed within the first 6 months, it is deemed to have been present at the point of purchase unless the trader can prove otherwise. So it's the next period of 6 months that this burden shifts, i.e. after 6 months, the burden shifts to you to prove that the defect was present at the point of purchase. Now, in the case of something which is hugely complex, perhaps for a laptop where there is a fault within the motherboard, which hasn't arisen from anything that you've done with it, which must, on the balance of probabilities, have been there at the outset, that is going to be more easily proved by you than, let's say, something physical and tangible that you may have dropped to cause some kind of problem. But as promised, I said I'm going to come back to a little gem, which is usually I've found with vehicles when you take them back for a repair. If very often you take it back within the first few days or the first week, or hopefully within the first 30 days, which is when you get this right to reject outright for a full refund, the trader may say, allow us an opportunity to repair it. So let's say that you go back to the dealer 15 days after purchase, so you're 15 days in and 15 days left of this right to reject period. The dealer then says, we will repair the vehicle. Whether it be one fault or numerous faults, it matters not. If the trader, and here's the gem, if the trader agrees to a repair of that vehicle, the period within which you are waiting for that vehicle to be repaired, or at least their attempted repairs, puts a stop on the period that you are entitled to reject that vehicle. So just to reiterate, if you go back on day 15 and the dealer agrees to attempt repairs on this vehicle, you still have 15 days left within which to reject the vehicle. If, let's say, 3 months' time, after numerous emails and telephone calls and visits to the dealer, where is my car, where is my car, where is the repair, why haven't you finished the repair, I want my car, where's the car, and then they finally say, well, here's the car, we've done what we can, it's still not quite fixed, but it's tough, you're now outside of the first 30 days, so we don't have to refund you. That's where the dealer is, and I'm going to be charitable, misunderstanding the law. Because, as I said, the waiting period, which is usually several months when they try to repair something, puts on hold this initial right to reject of the first 30 days. So when you go back and say, forget it, I want my money back, I'm fed up of waiting for the repair, or you're not happy with the repair because the repair didn't solve the problem, you can then exercise your right to reject the vehicle at that point in time, because you still have 15 days within which to do so. Now, there are some caveats, of course, to all of this, in that if there's a big scrape down the side of the vehicle and they point it out to you and say, this is a fantastic vehicle, but for the fact there's a huge scrape down the side, then of course they've drawn your attention to that and you go ahead and purchase the vehicle. You cannot then go back and say, I want that repaired, unless of course that was agreed as part of the sales process in the first place. However, if the scrape is, let's say, round the back of the vehicle, down the side somewhere where you wouldn't necessarily look at it, and they did not draw your attention to it, then having not drawn your attention to the defect in the first place and having told you that this is in otherwise perfectly good condition, that is obviously something that you can go back and say, this is not of satisfactory quality because you told me it was as new, i.e. nothing wrong with it. But you then discover there is something wrong with it. Maybe it's a boot latch or something that doesn't quite work. You can go back and say, well, you told me everything was in working order, it was as new, or whatever the phrasing was, and it's not of satisfactory quality because of this defect. That of course applies predominantly to second-hand vehicles and anything else that's second-hand that is likely to get some scrapes and bangs. But in the case of a new vehicle, particularly if it is an expensive vehicle, there is case law to say that the more expensive an item, the more you should expect from that item. I.e., quite simply put, if you buy something cheap, it's not expected to last as long, it's not expected to be quite as good quality as something that's very expensive. So the more you pay, the more you can expect. If you've bought a brand new vehicle and there is even the slightest little scratch somewhere, the Consumer Rights Act provides that it should be free of defects. So if the car arrives and it has a defect, you have the right to reject that vehicle. It's a statutory right and you have a right to uphold that as a term of the contract. Although, dare I say, most traders, in my experience with the cases that I've come across, will fight you on it and will try everything they can to not give you your money back, even though it is a right to reject the vehicle because there's a defect. It is defective in one sense or another. You can, at your discretion, accept some monetary discount, or potentially you could accept a replacement, but that's down to you and the trader. So long as I said, you're within this period to reject the vehicle, you have that opportunity to do so. So just as I said at the outset to the video, all of these phrases, sold as seen, buyer beware, trade sale only, no returns, no refunds, some of those are actually breaking various other regulations, such as trade regulations, that they are not allowed to say. For example, they cannot tell you that you don't have a statutory right as a consumer, when in fact you do. But more broadly, all of those terms mean pretty much nothing when it comes to contract law. I hope that was useful. I'm sure every one of you at least some stage either have or will be in this position, and hopefully will remember this video or share it with someone that is or was in that position. Please like the video and subscribe, and as always, thank you so much for watching.